waiting room. It doesn't look like he's in my courtroom.
He's in jail, Your Honor.
Oh, okay. I don't have him yet, so.
I understand that, but this is the one that I'd asked to put out due to the fact that it's a violation of probation and he's not
Right,
getting
but do
out.
I need him here on the record to do that?
No, Your Honor. He has a felony pending. And so we're
Well,
trying
I
to get the
understand that, but
felony and the BOP up here
Okay.
together.
I didn't understand.
okay, hold on, because he was talking to, bye, Mr. Brown.
Have a good Thanksgiving.
You too. All right, Ms. Van Dusen, usually I bring them over just to give notice on the record, but do you need him brought up or zoomed in for that?
No, he's not getting released, Your Honor. So he
Okay,
is
so in the
jail.
matter of, hold on, the people of the state of Michigan versus Michael Anthony Nolan, we have 3 files, 2019-19726 FH, 2019-19727 FH, and 20-19945 FH. Oh wait, not that one, just the two, 19727. So strike the 20-19945. So I have Dawn Van Dusen appearing on behalf of Mr. Nolan. This was a probation violation hearing. You said his next hearing is December 1.
That's correct, Your Honor. That's down in circuit court.
District court, I mean?
District court, I'm sorry. And then, so I'm assuming 2 weeks after that, it would be arraigned up
My
to
next
you.
available is December 7 or December 28.
28th, please, Your Honor.
Okay, so we'll set rearrangement pretrial over to December 28th at 8:30. And all right, that'll take care of Mr. Nolan.
And I will send notice over to him, Your Honor.
You'll do the, I think on the violations of probations, we do the notices and stuff.
Okay, thank you.
So you don't have to do that. Notice on that one. All right, Ms. Barrett, can you hear me?
Yes, ma'am. Yes.
Okay, this is in the matter of the people of the state of Michigan versus Samantha Jo Barrett. We have 3 files, 2019-19322 FH, 22-20769 FH, and 22-20770 FH. I have Dawn Van Dusen appearing on behalf of Ms. Barrett. And I have Ms. Holly appearing from the Michigan Department of Corrections on behalf of Ms. Tusky. Ms. Barrett, this is the date and time set for sentencing on a probation violation. Ms. Barrett, have you received a copy of the probation violation report?
No, ma'am.
Right, Ms. Van Dusen, do you have a moment to meet with her?
Yes, Your Honor.
All right, so Ms. Barrett, I am going to open a breakout room for you and Ms. Van Dusen.
Okay.
And go ahead and click on join. Right. Is anyone a defendant here that has court case?
I'm here with Matthew.
Okay, I don't have Mr. Murphy yet. What's your last name? Brooks?
Holbrook.
Holbrooks. Okay, all right, got it. And write that down. On page 3. All right. Right. I'm assuming Mr. Murphy. Matthew Murphy.
Good morning.
Good morning. Ms. Holbrook, do you want to step up to the podium? Want to come on up here? What you got? You got something for me? Yeah. Oh, they already did.
Oh, they did?
No, they adjourned
Okay.
because he's.
Okay.
That's fine with me.
Okay.
All right,
I'll
thanks.
do some paperwork.
Oh, you want me to?
Yeah.
Okay. I'll let Ms. Van Duzen know too.
Okay.
I know. Ms. Adams.
Yes.
Here.
Mr. Stevenson is here on Mr. Nolan, so you don't need to do that paperwork. Ms. Van Duzen, Mr. Stevenson is brought over to discharge from probations on Mr. Nolan,
Okay, thank you.
so we won't need to come back on December 28th.
Okay.
All right, thank you.
Thank you.
All right, so on page 2, Mr. Nolan, we'll just discharge him. Okay. Okay, so let me bring Ms. Barrett back.
Yeah, we don't have a PSI.
Oh, it probably went to Rhonda Underwood at her private email. So Ms.
Probably.
Adams, could you email to Ms. Van Duzen the probation violation report? All right, Mr. Murphy, I have Ms. Holbrook here. So this is in the matter of the people of the state of Michigan versus Rose Allen Holbrook, file number 22-21029FH. I have Matthew Murphy appearing on behalf of Ms. Holbrook, and I have Christopher Fleming appearing on behalf of the people. Mr. Murphy, how do you wish to proceed today?
Your Honor, I was going to ask if we could set a jury trial on this matter. I think
All
it
right,
would probably
has there been-
take one day.
Okay, has there been a plea offer made in this case?
There was a preliminary examination. I don't know if there's been an offer made since that preliminary examination.
Mr. Fleming?
I don't know yet, Judge. I didn't know I was covering things this morning. Give me one moment. I'll have it pulled up in a sec.
Did you order, oh, I do have an order for the transcript.
We already have the preliminary exam transcript, Your Honor.
I don't have it yet. That's why I was looking. It's not in my file. It's probably across the hall on a shelf.
What we have in the file from July 25th is as charged with a delayed sentence under 771.
No upfront jail.
I'm sure would not guideline high, Judge.
So Mr. Murphy, that would be a delayed, would that be with Mr. Coast?
It would be.
My chart. So Mr. Murphy, a delayed. Would they consider it deferred?
I mean, I would think would delay would be even better than a deferred, Judge, but
Well, the conviction remains on a delayed and not on a deferred. Because it could impact,
I don't think there's any possible options for deferment.
Okay, so what I'm gonna do, Mr. Murphy, is I'm gonna set this for another pretrial. And then have you meet with the prosecutor. If you want to have a bench conference with me, that's fine. I'm gonna set this out to January 25th at 8:30 in the morning for a pretrial. And I'll get a notice to Ms. Holbrook because she's here today. So Ms.
Okay.
Adams, I know I just asked you to do something else, but could I get a notice for Ms. Holbrook for January 25th at 8:30? If you want to just have a seat, we'll get you another notice, okay?
Ms. Holbrook, could you contact my office next week and try to schedule an appointment before that date?
Okay.
Thank you.
All right, in my waiting room, I have Okay. Happy Thanksgiving. That one. All right, Mr. Muwad, I do not see your client in my, well, I don't know. Let me see, a Samsung just came in. All right, I have someone in a car on a Samsung device. Can I ask your name, please?
Jacoby Lyles.
Say it again.
Jacoby Lyles.
All right, hold on 1 second.
I'm not sure if I'm in the right one because I was told
You
All
are
Saver is
where
not in
you-
today.
Hold on, Mr. Lyles, you are where you are supposed to be.
Yes, ma'am.
All right, so Mr.
Okay,
Murphy,
thank
Mr.
you.
Lyles is yours. All right, this is in the matter of the people of the state of Michigan versus Jacoby Wayne Lyles, file number 22-21135 FH. I have Matthew Murphy appearing on behalf of Mr. Lyles, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for arraignment in this matter, and a waiver was not filed. So, Mr. Murphy, do you wish to waive the reading of the information?
Yes, Your Honor, we waive a reading of the information. We acknowledge receipt of said information at this time, the witness list and discovery demand from the prosecution in this matter. I was hoping to have this in front of Judge Olsaver because Mr. Lyles has probation in front of Judge Olsaver. That's why we didn't waive. But I would ask at this time just to enter a not guilty plea, set a pretrial so we can get this as soon as possible in front of Judge Olsaver and enter a plea agreement that we already have worked out.
Don't you want to just plead them today?
Well, I didn't know if Mr. Lyles wanted to, because I believe he wanted to have it done in front of Judge Olsaver.
So,
If he was fine with doing it today, we could just do it today.
well, I mean, so Mr. Lyles, Judge Olsaver is off this week, and I'm filling in for him. So if you wanted to plea in front of me, that would be fine, but you would be sentenced by Judge Olsaver.
Right. I mean, I'm fine with that as long as, because we already had it written in document prosecuting. They already said that it was okay for or for it to be dropped to disorderly and nothing but fines and costs. If we could go with that, then run with it. But I mean,
And Your Honor, we can enter a plea of guilty then today to disorderly.
All right. Okay, Mr. Lyles, will you raise your right hand for me, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Is that a yes?
yes, ma'am.
All right, so Mr. Murphy, could you put the plea on the record, please?
Yes, Your Honor. This case was a plea agreement involving another case, but in this file, Mr. Lyles was going to plead guilty to disorderly conduct with the Killebrew agreement to just fines and costs in this matter. There was another case that Mr. Lyles has already been sentenced to probation on that was involved in the matter as well.
Okay, so it's gonna plead to count 2 disorderly. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
And then there'd be no objection to fines and costs. Would that be sentenced today or it's a victim crime, so I need to set it out 30 days for sentencing? Is that correct, Mr. Sneed?
I believe so, Judge, yes.
All right, Ms. Adams, let me see what I got from Mr. Judge Saber's office. All right, sentencing would be January 12th at 8:15. All right.
Is there an amended?
Yes. All right, so Mr. Sneed, could I get that amended information today, please?
Yes, Your Honor, thank you.
Okay, so Mr. Lyles, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2 disorderly, which is a 93-day misdemeanor with the agreement that it would be fines and costs only? So is that your intention?
Yes, ma'am. That is my intention.
Very good. Are you satisfied with Mr. Murphy as your attorney and the advice that he has given you? All
Yes, ma'am.
right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had at trial. I'm going to explain those rights to you to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
I mean, as long as it's strictly fines and
Mr.
costs, and
Lyles,
yes,
Mr.
ma'am.
Lyles, I want you to listen to the question that I ask you and
Yes,
just
ma'am.
answer that
I heard
question.
exactly what you said. Yes, ma'am.
Okay, so do you understand you're giving up rights to appeal issues that would be appealable if you'd been convicted at trial instead of by taking a plea? Do you understand that?
Yes, ma'am.
All right, do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Do you understand that if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization? Do you understand that?
Yes, ma'am.
Do you have any questions about the rights that I've given to you?
No, ma'am, I do not.
All right, so sir, how do you wish to plead to the charge that on or about July 24th of 2022 in Cambridge Township in the county of Lenawee that you did commit the offense of disorderly conduct? Guilty or not guilty?
Guilty.
Okay, now, has anyone made any threats or promises to you to induce you to plead guilty other than what was placed on the record today?
No, ma'am.
All right, do you understand if I accept the plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that? Do you understand?
Yes, ma'am, I do.
Okay, all right. So is the prosecutor or defense counsel aware of any other promises or threats than the plea bargain to induce the defendant to plead guilty? Mr. Sneed,
No, Your Honor. Thank you.
Mr. Murphy?
Yes,
No,
ma'am.
Your Honor.
Okay. Sir, is it your own choice to plead guilty?
Yes, ma'am, it is.
Okay, so Mr. Lyles, on July 24th of 22, were you in Cambridge Township in the county of Lenawee?
Yes, ma'am, I was.
And then did you come in contact with a Michigan State trooper named Renee Gonzalez?
I mean, I'm guessing so.
Well, I'm guessing that on that day you were
Right back
disorderly
to-
and it involved.
I'm not sure what is, I think it was Gonzalez.
Okay, let me back up. Did you come in contact with the Michigan State trooper?
Yes, ma'am, I did.
Was it a woman?
No, it was a man.
Oh, okay. So, and if I told you that your attorney and the prosecutor agree that that trooper's name was Renee Gonzalez, would you dispute that?
I mean, I wouldn't dispute it. I mean, some people name their boys girl names, so I mean, I don't know.
Okay. Well, it might
It looked
be
like a dude.
Mr. Lyles, it might be a Hispanic name. So,
Yes, ma'am.
all right, so Mr. Lyles, at some point, did you get loud enough that another party could have heard you, or did you get a little rowdy or something?
Not really. I was helping my buddy off off the ground because he's passed out up against the fence. And the
So I'm
cop
gonna
come up
guess
from
this was Faster Horses weekend, is that right?
yes, ma'am, it was.
Okay, Mr. Murphy, you wanna help me out a little bit with this?
Yes, Mr. Lyles, I thought in our conversation, remember when you had discussed this before, during the process of helping your buddy up, you would agree that you two were being disorderly, you guys are being rowdy, that drew the attention of the police. Would you
I
agree with
mean,
that?
he swung on me and I grabbed him by his arm. So yeah, I guess so.
Yeah, and both of you were engaging in behavior that caused a disturbance. You would agree with that? Not, you weren't fighting, but you guys are being
Yeah.
rowdy. You would agree with that?
Yeah, yeah,
And that drew the attention of other individuals in the area?
yeah.
Mr. Sneed, are you satisfied?
I am, Judge. Thank you.
All right, has the court complied with the MCR 6.302 B, C, and D? Mr. Sneed,
Yes, Judge. Thank you.
Mr. Murphy?
Yes, Your Honor. Thank you.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Lau, we talked about this already, but you're willing to waive being sentenced by me so that you can go be sentenced by Judge Olsaver. Is that correct?
Yes, ma'am.
Okay, now my next question, Mr. Lyle, is do you want to have to appear in person or do you want to appear via Zoom for sentencing?
And whatever fits y'all best. It doesn't matter to me.
Okay, how about we do Zoom?
That'll work.
And Mr.
All
Lyles,
right.
if you have any problem with Zooming, you can come to my office, okay?
Yeah, I was having a problem this morning.
Okay.
And
All right, so I'm going to set this matter for sentencing on January 12th at 8:15 in the morning via Zoom. So Mr. Lyle, I'm going to put you in a breakout room with Miss Holly from the Michigan Department of Corrections. And she's gonna explain to you the 2 steps you have to do, because we have to do a pre-sentence report. Even though there's agreement to fines and costs, we still have to do that report, and you have to comply with what we require of you for that. So I'm going to put you in a breakout room, as I said, with Miss Holly, and you go talk to her for a moment. And when you're done talking to her, you can hang up and go on your way. All right?
all right, yes, ma'am.
Do you see the invitation to join the breakout room? All right, Mr. Lowe, can you hear me?
Yes, I can.
Okay, let's see. There we go. All right, this is in the matter of the people of the state of Michigan versus Cody Joseph Lowe, file number 21-20527FC. I have Elias Mawad appearing on behalf of Mr. Lowe. Mr. Lowe is appearing via Zoom, and I have Christopher Fleming appearing on behalf of the people. This is a date time set for a pretrial conference in this matter. Mr. Mawad, how would you like to proceed today?
Your Honor, from when we were here last time, I was supposed to get you a guidelines and discussion of potential cops plea to you and to Mr. Fleming. We thought there was maybe another case popping up. Mr. Fleming knows we've talked about it, so I backed off on it. But I think that's not an issue anymore. I'd like to see if we can get one more date into the new year, after the new year, maybe the second week, and I will be working on that and get that over to the court and to Mr. Fleming. And so I can discuss this with my client. That'd be great.
All right, are you available January 11th at 8:30?
Sure, Judge, that works.
All right, and we will set this January 11th at 8:30. That'll be via Zoom. And Mr. Mawad, you'll do the step in order to adjourn.
I'll do it, Judge. I have a quick question for you. I'm actually going to be in your courthouse this afternoon for a district court matter. I have to swing by your courtroom to bring an order to terminate a PPO. because the CPS has kind of taken over the whole thing between the petitioner and the wife, the husband and wife. You guys gonna be in this afternoon if I bring it to you? Do you think or no?
The courthouse is open and I would be available to sign anything, yes.
All right, we'll see you guys later.
You would just have to take it to the clerk's office and they'll get it to me, all right?
I can do that, Judge. I appreciate it. Thank you very much. Thank you.
All right,
Chris,
thank you and
But-
happy Thanksgiving.
I'll
Mr.
see
Lowe, you're
everybody.
all set.
Thank you. Thank you very much.
Thank you, Your Honor.
Thank you. All right, Ms. Van Duzen, are you ready on Miss Barrett? Where'd she go? Yeah, there she is.
Sorry, Your Honor, I was shopping. But yes, I'm ready.
It is a good day to do that, especially because we got paid a day early, right?
Yes,
So,
definitely.
we're back on the record in the matter of the people of the state of Michigan versus Samantha Jo Barrett. Now, Ms. Barrett, have you had an opportunity to review the probation violation report with Ms. Van Duzen?
Yes, ma'am.
All right, are you satisfied with Ms. Van Duzen and the advice that she's given you?
Yes, ma'am.
All right, Ms. Van Duzen, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Ms. Barrett?
Just, Your Honor, I'd ask that you follow the recommendation as I think it's adequate. She is a drug addict and, you know, will benefit from the drug court. I think this is an eye opener for her for the violation. So I hope that she will continue her progress in the program.
All right, Ms. Barrett, anything you'd like to say?
No, I appreciate that. I was doing really good and it really is an eye opener because I do hate being in here. So I will continue to do good on it.
All right, well, it's a sentence of the court that you'll be continued on probation and in the adult drug treatment court. You'll serve 15 days in jail, credit for 7 days already served. Ms. Barrett, the next violation though, you're gonna have to go to a rehab facility. Do you understand that?
Yes, ma'am.
And don't ever run from this hallway again. Do you understand me?
Yes, ma'am.
All right, now you do have the right to appeal this sentence. They're gonna give you 3 copies of your notice of right to appellate review, and you're gonna sign those acknowledging you received them. If you wish to appeal your sentence, you would fill out the information on the forms and mail them to the address listed on the form within 42 days. All right?
Okay.
All right, thank you, Ms. Barrett. Good luck to you.
Thank you.
Thank you. Mr. Blazer, I think you only have 1 file with me today. Got Michael
That's correct, Your Honor.
Marcosian, he's only got 1 file. Who is it you have, Mr. Blazer?
I have Caleb Young.
Caleb Young. All right, Mr. Margosian, you got here first, but Mr. Glazier, I had to take him because he's your superior. All right,
I understand, Judge.
I don't know about that, Judge. I think everybody's his superior. He's a Sparty fan.
he's a what? A Sparty fan like me?
Oh, you're a Sparty fan? Oh, Judge.
I'm alumni. Yeah.
Oh,
Right.
man.
I'm also Ohio State fan, so
You
know,
both? That's like a double whammy.
anybody that can beat Michigan. All right, so I have Caleb Young. Is he in jail?
I believe so, Your Honor.
All right, Becky, if I can get Caleb Young, so Mr. Dagger Margosian, I guess I just skip over to you. You're on page 3 of mine. You have Erin Carr. I do have Erin Carr. She's joining. And all right, Ms. Carr, can you hear me? Erin Carr, oh, she's not connected. Okay. Just send her a message to connect to audio.
Judge, we may have to pass that matter just momentarily. We're trying to finalize what's going to happen on it.
All right. All right, so Ms. Carr, I just wanted to let you know that Mr. Dagger Margosian is communicating right now about your case. So when he's ready, we'll bring you back in, okay?
Okay, thank you.
Thank you.
And I have Tony Rowe, I think, pick up.
All right, so I have one jail window, so
Okay,
there's nobody there, so
okay, I'll just keep shopping.
yeah, keep shopping. I know that Target had some good sales this morning. All right.
Ooh.
And Kohl's.
I'm a size XL, Dawn.
Mm-hmm.
Well, my husband's a giant, so I can't ever buy clothes from him anywhere except.
I bet. He's even above the
Alright.
tall.
Yeah. All right, so there's Kayla Young. Sure. We'll save the file. All right, I have Jackson Yancey, Christina Morgan, Ronald Wood, and Stephanie. My guess is Stephanie Pate and Miss Adams. If it is Stephanie Pate, then Mr. Leon, I need him and haven't seen Mr. Leon. Anybody represent Ronald Wood?
I do, Your Honor.
Right. Is you too, right? Okay. Miss Pate,
Yes.
all right, I'm gonna change your screen name. Is Mr. Leon still your attorney?
As far as I know, I've been trying to contact him by email for a while now, so I haven't got once. I tried to call him, so.
Okay, I'm gonna put you in the waiting room and we'll try to find him too, all right?
Okay, thank you.
All right. All right, Mr. Wood, can you hear me?
Yes.
All right, this is in the matter of the people of the state of Michigan versus Ronald J. Wood, file number 22-20782FH. I have Matthew Murphy appearing on behalf of Mr. Wood, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. So, Mr. Murphy, how would you like to proceed today? It looks like there is also a contempt of court. All right.
Your Honor, could I have a brief breakout session with Mr. Wood before we proceed?
Okay, so, very brief though, because I don't have, let's see, so Mr. Wood, I'm gonna assign you to a breakout room, you're gonna get an invitation, go ahead and join it. Now, when you're done, you have to come back.
Yeah.
Okay.
Like I was telling you, mural, another one that I hated. This was, we had an officer, Toby Butler passed away.
Nancy is Mr. Murphy. Christine Morgan is Mr. Murphy. Okay.
And, ended, ended up dying. He was over 40 and it was worth it.
Well, you can issue insurance for people that.
He just kind of a board of things with, he was big into college and all that kind of stuff.
Becky, I also do not have Mr. Daly. I'm Mr. Van Meldigan.
Okay.
I thought.
That have mental health issues or, what they think are mental health issues, he sees them, sorts it out, figures out what they need to help them do their stay.
So, in the matter of the people of the state of Michigan versus Jeffrey J. Van Meldigan, file number 19-19709 FC. The last notice of hearing I have in the file is for November 2nd. I don't have a notice for today.
Somewhat level, yeah, manageable. Everybody's looking over here, this block over here, or this end, block we're looking over there, sub block, that's, medium security, people look for all 2-man cells. Each room has bunks, top bunk and bottom bunk. There's 44 rooms in there. We can put 44 in there. So right now, they're just kind of out first thing in the morning, they come out clean, different things. They'll make shut their doors at lunchtime and then they can.
Judge, it looks like on November 2nd, it says defendant can connect to Zoom, hearing adjourned to November 23rd.
Right, does there a stipend order or notice of hearing? Because I don't have a notice of hearing in the file for today. Which if I don't have one, the defendant may not have one either.
I don't see anything scanned in.
All right, so Ms. Adams, in that case, file number 19-19709 FC. Ms. Adams, if we can set that over to December 7th for pre-trial, and can we mail out the notice?
Okay.
All right, you're the best, Ms. Adams.
Time.
Always. Yep, 8:30, yeah. So that'll be December 7th at 8:30 pre-trial. Thank you, Ms. Adams. All right. That one, Mr. Murphy. I'm trying to move Mr. Wood back to the main session. Sometimes it works. Sometimes it doesn't. All right, we are back on the record in the matter of the people of the state of Michigan versus Ronald J. Wood. Mr. Murphy, you would ask for a breakout room with your client. Are you ready to proceed now?
Yes, Your Honor, thank you.
How would you like to proceed?
Your Honor, we're going to ask if we could set another pretrial on this matter. I've asked Mr. Wood to call and schedule an appointment before then. So hopefully we can get the matter discussed and figured out at the next pretrial. If we're going to resolve the case, we're going to set it at trial.
All right, so I'm going to set this matter for a pretrial on January 18th at 8:30 in the morning. Mr. Wood, make sure you schedule an appointment with Mr. Murphy. And Mr. Murphy, just for my file, is there a plea offer been made in this file?
Your Honor, there was a plea offer of an OWI first, but that was back down in district court. And that was a while ago. I don't know if that was still on the table or not.
Mr. Sneed?
It's Miss Mears' case, Judge, so I'd ask Mr. Murphy to follow up with her prior to the next pretrial.
All right.
Because that was prior
Okay.
to the holding the exam, and so there hasn't been one
Okay.
discussed since then, or given since
All
then.
right.
Thank you.
Okay, we'll see you back on January 18th, Mr. Wood, at 8:30 in the morning, and Mr. Murphy, you will do the notice of hearing, stipend order. I do have, let's see, there is a contempt of court for failure to appear for the pretrial on June 1. He's continued to appear, so I will set that over to the same day as well.
Thank you, Your Honor.
All right, thank you, Mr. Wood.
Thank you. Are we done?
You are done, you can disconnect. Thank you.
Okay.
Thank you, Mr. Wood.
All right, Mr. Murphy, in the matter, let me bring Mr. Yancey in. Let's get him connected to audio. All right, Mr. Yancey, can you hear me?
Yes, ma'am.
All right, so this is in the matter of the people of the state of Michigan versus Jackson Bailey Wayne Yancey, file number 22-21041FH. And Matthew Murphy appearing on behalf of Mr. Yancey. And I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial in this matter. Mr. Murphy, how would you like to proceed today?
Your Honor, I would ask for another pretrial on this matter. We have the preliminary exam transcript. I was gonna try to file a motion in this matter before, I think, setting a trial on this matter. We did have a preliminary exam, as I had said. There was an offer prior to the exam of an aggravated assault. And then after the exam, though, there hasn't been an offer made, and there was an added count of aggravated assault added on to the, I believe, what Ms. Meir added onto the information. But at this time, I'll just ask for another pretrial.
All right, we'll set this for another pretrial on January 18th at 8:30 in the morning. And hopefully you'll be able to get that information before that hearing. So Mr. Yancey, you'll zoom into the same number you used today on January 18th at 8:30 in the morning. And Mr. Murphy, you'll do the step in order to adjourn. Is that correct?
Yes, Your Honor.
All right, Mr. Yancey, you're all set. You can disconnect.
Thank you, ma'am.
Thank you.
All right, Mr. Murphy, I have Morgan. All right, Miss Morgan, can you hear me?
Yes.
All right, this is in the matter of the people of the state of Michigan versus Christina Morgan. We have three files, 22-20937FH, 22-20938FH, and 22-20939FH. I have Matthew Murphy appearing on behalf of Miss Morgan, and I have Isaac Sneed appearing on behalf of the people. Mr. Murphy, this is the date and time set for a pretrial. How do you wish to proceed today?
Your Honor, I was going to ask if we could do another pretrial, but maybe a bit further than the other ones have been scheduled, maybe later in January or into February. I needed to do, or I needed to talk to Ms. Morgan a bit more about the case and other issues in this matter.
All right, this will be the third pretrial, so I think I'd rather, this is the fourth pretrial, so I think I'd rather set a trial date on this.
Yes, Your Honor.
Tell Becky that I have one jail window open. I'm running 2 courts and I've been waiting for 20 minutes. Okay. So maybe call the jail again. So, all right, we'll fill this out. So it'll be 37, 38, 39. Would these cases be tried together or separately?
I think they would be separate, Your Honor.
All right, because I didn't know the circumstances. All right, so the 22-20937FH file would be the primary for trial. And yeah, hold on a second, I'll put this in here. All right, so this is a retail fraud first degree, which carries a maximum penalty of up to 10 years in prison because of the habitual supplement. And retail fraud's a 5-year, and she has a third offense notice, so that would make the maximum penalty up to 10 years in prison upon conviction. But because it's a retail fraud, I'm assuming that would be a 1-day jury trial.
Yes, Judge.
Yes, Your Honor.
All right, so Ms. Adams, could I get a jury trial date in February or March, please, for 1 day?
Okay, March 8th is a Wednesday, would be day 2 with William Badger.
Who's the attorney on that one?
O'Keefe.
Yeah, we could do it that day. What was the date again?
Wednesday, March 8th, unless you want to do Thursday.
Let's do March 9 then at 9 o'clock.
Okay.
Mr. Murphy, March 9 at 9 a.m. for trial.
Yes, Your Honor. That works.
It's good with the people, Judge.
I always assume you guys rotate around, so the dates I usually assume are good for the people. All right, so the trial will be in person, and I will set a final pre-trial for February 8th. And that would be on all files at 8:30 in the morning. That can be via Zoom. And I will require that by February 24, that would be the motion deadline, as well as jury instructions, voir dire questions being due. Obviously, if you reach a resolution before that, I would ask that you bring her in advance. And let's see. All right, Ms. Morgan, make sure you stay in contact and meet with your attorney. In
And Ms.
advance
Morgan,
so that
can you call my office next week and schedule an appointment, please? Thank you.
Right. All right, I filled out the scheduling order and we will get that out to everybody. Thank you very much.
Thank you, Your Honor.
All right, so who do I have from the jail?
Caleb Young.
What's your last name again? Young?
Yes, ma'am.
Okay. Okay, give me 1 second. All right, so this is in the matter of the people of the state of Michigan versus Caleb Matthew Young, file number 22-21137FH. I have John Glazier appearing on behalf of Mr. Young. And I have Isaac Sneed appearing on behalf of the people. This is a date and time set for arraignment in front of Judge Olsaber. I'm handling his arraignments today. Mr. Glazier, do you waive the reading of the felony information?
I do, Your Honor. We'd waive the reading of the information, acknowledge receipt of that, as well as the attached witness list, prosecutor's request for discovery. At this time, we'd enter a plea not guilty. Your Honor, actually, we might enter a plea, but I need to speak with my client first. We might enter a plea.
That's fine. All right, so I'm going to close all these breakout rooms. So Mr. Young, in a moment here, I'm going to open up a breakout room. And you will click on join, and that'll give you an opportunity to speak with Mr. Glazier. So, Mr. Glazier in the jail. All right, you should get an invitation to join that breakout room. All right, I have Upshaw. Mr. Dagger Margosian, I do have Erin Carr in the waiting room, so whenever are you ready for her?
Yes, Your Honor.
Okay. So we are back on the record in the matter of the people of the state of Michigan versus Erin Michelle Carr. Mr. Upshaw, your attorney, or Mr. Upshaw, can you hear me? Mr. Upshaw, can you hear me?
Yes, I can. Yes,
All
Your
right, I do not have your client yet, so if you want to give him a call.
I just gave her your Zoom number, Your Honor. She had missed
Okay.
Zoom, so she should be zooming in any moment.
All right, perfect. Okay, so this is in the matter of the people of the state of Michigan versus Erin Michelle Carr, file number 22-21103FH. I have Michael Dagger Margosian appearing on behalf of Ms. Carr and Isaac Sneed appearing on behalf of the people. I do have a note from Darren Coast in the file that I would share with you, Mr. Dagger Margosian and Mr. Sneed, stating that Mr. Coast currently has Ms. Carr on probation on a deferred case, and that she is doing her drug screens as required and is doing very well. She is engaged in individual and group counseling and attending AA on a regular basis and appears to be serious in her recovery. So I wanted to share that information with you, Mr. Sneed and Mr. Dagger Margosian and Ms. Carr. Good for you. So how do you wish to proceed today, Mr. Dagger Margosian?
Your Honor, Michael Dagger Margosian for Ms. Carr. Your Honor, we do have a resolution, and it's sort of in line with what you just put on record. Basically, this is Ms. Mears' case. Her and I came to an agreement in district court that we would waive the exam and that Ms. Carr would enter a plea to a misdemeanor upstairs because she is already on probation with you. So what will happen in this case is that the information will be amended to account 2 of brandishing a weapon. That's going to be 750.234E. And we would just ask for an immediate sentence to just mirror what she's already doing with Mr. Coast, as well as it being delayed/deferred.
Delayed or deferred?
Well, I know we've sort of gone back and forth. I mean, essentially, ultimately the result will be once Ms. Carr completes her supervision, the case will be dismissed.
Okay, so what I have, my little cheat sheet
I know,
that the
I know.
state gave me.
Yep.
A dismissal comes under deferred, well, it's guaranteed under the deferred where it's not under a delayed. Mr. Sneed, any input?
We would defer to the court or to Mr. Dagger Margosian for which they would like to use.
If these are, Your Honor, if the other cases are already deferred, then I'll just ask the court to just have this be the same as those.
Okay, so Mr. Sneed, you have no objection to a deferred?
Correct. Thank
Okay, but that would require me to put her on probation, pre-probation with Mr. Coast, like she is on her other file. Do you understand that?
Correct.
Okay. And Mr. Sneed, will you amend the information for brandishing? What is that, like a 93-day misdemeanor?
It's a 90-day.
90-day.
We're preparing that now.
Okay. All right. So Ms. Carr, you want to raise your right hand? All right. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Now, Ms. Carr, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to enter plea of guilty to a misdemeanor count of brandishing a weapon, which is a 90-day misdemeanor?
Yes.
All right, and you understand that would be under the deferred statute, which if Ms. Adams or Ms. McGrain, could you let Mr. Coast know in case he wants to log in, which means that you'll be placed on probation with our pretrial services in order to comply, and failure to do so could end up with the conviction being entered. Do you understand that?
I do. I do have a question. I just am curious, is anything going to change?
No. You
Okay.
just keep doing what you do with Mr. Coast
Okay.
in
Yeah,
terms of probation. Okay. All right. Are you satisfied with Mr. Dagger Margosian and the advice that he has given you?
Absolutely.
Okay. Now, so basically, Mr. Dagger Margosian, we're saying there's no upfront jail. It'd be a deferred sentence. You can continue to comply. And if she successfully completes that term, the charges would be dismissed.
Correct. And I guess the only thing that I would add is Ms. Carr has 3 cases that she already is on deferred status with, Your Honor. If we could just, and this instant case is about a month after those things.
They would run with it.
Yeah, run with it. But just if we could keep the end date as the end date, I think that would make sense for all of these.
Okay, so Mr. Coast, Ms. Carr is going to enter, I'm going to take a plea under advisement for a deferred judgment of guilt on a new file, and it would be for brandishing a weapon, which is the 90-day. So she would continue with pretrial services, probation for whatever term is left.
Correct, and I believe her expiration is
I think it's August 11th of 23, if I'm not mistaken.
Yeah.
I believe that's correct.
Okay, okay. So did that answer your question, Ms. Carr?
It did, yes. And I just, one more thing. I was wondering about the bond, and I had talked to Michael about it yesterday, so I just wanted to touch base about that.
I'm going to address that after we go through the
okay
portion.
Okay.
Okay, so you're satisfied with Mr. Dagger Margosian as your attorney?
Yes.
All right, I don't think I swore in, did I? So Ms. Carr, raise your right hand.
Yes, I did do this already, but that's okay.
Okay, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
I have a certain order, way I do things, and otherwise I forget, and Mr. Dagger Margosian always like takes me down another path and I forget. All right, so, you understand the maximum penalty for this offense could be up to 90 days in jail though. Okay, and, let's see, we basically have an offer and regarding sentencing. So ma'am, do you understand? I'm going to be taking your guilty plea under advisement, and if I do that, there will be no trial. Do you understand that?
I do.
This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right, how do you wish to plead to the charge that on or about, let's see, September 28th of 2022 in the city of Adrian in the county of Lenawee, that you did brandish a weapon?
I did.
Well, it have to be a guilty or not guilty.
Oh, guilty. Sorry.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Dagger Margosian?
No, Your Honor.
Has your attorney, so we've already talked about waiver sentences, never mind. Is it your own choice to plead guilty?
Yes.
Okay, so, ma'am, on September 28th of 2022, you're in the city of Adrian in the county of Lenawee?
Yes.
And did you have on your possession brass knuckles?
I did.
Did you have them on your hand?
No, they were in the bottom of my purse.
Okay, and it's illegal to possess those, is that correct?
It is. I did not know that, but
Well, all right, but ignorance of a law doesn't make it a valid defense. So you understand that it wasn't legal for you to carry brass knuckles?
I agree. I understand.
All right, Mr. Dagger Margosian, for purposes of the plea, I took the plea to count 1 versus the added count 2 disorderly. Are you satisfied with that?
Yes, Your Honor, thank you.
Mr. Sneed?
Yes, Your Honor. Thank you.
Has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, it has.
Mr. Dagger Margosian?
Yes.
All right, I will take the plea under advisement. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. There has been an agreement placed on the record. I will place you, do we want to do a PSI, or can we just place her on deferred today?
We can just place her on deferred today, Judge, since there's no victim. Also, the expiration on the other file is 10/21/23.
All right, so the expiration of your deferred sentence, Ms. Carr, is actually in October of 2023. All right, so Ms. Carr, what I will do at this point is place you on probation with our pretrial services with Mr. Coast. I'm going to order that you pay, let's see, did I order the $750 in court costs on the other file? I don't think so. Because that was the first one, right?
Right.
All right, so Ms. Carr, I'm going to order that as a term of that probation that you pay $750 in court costs, $450 in attorney fees. This is a misdemeanor, so I believe there's a $75 crime victim rights fee, and I believe it's $50 state cost fee. And would there be a law enforcement fee on this one? Right, there may be $100 law enforcement fee on this one. And then without electronic monitoring, there is a $30 per month supervision fee. All right, Ms. Carr. So Mr. Coast will give you a monthly amount that at the minimum needs to be paid on that every month so that it's paid off by the time you're done in October. And Mr. Dagger-Margosian and Mr. Sneed, you have no objection to waiving a PSI because of the nature of the charge. Is that correct?
Yes, Your Honor.
I don't have any, Judge, I'm sorry, I don't have any objection. I know that Mr. Coast just said the expiration date was in October. I had it written down as August 11th of next year. Is that not, that's not the case then?
It would be 11 months, so Mr. Coast will check into
All right,
that.
that's fair. The only other thing that I'd like to address is the bond, and I don't know if Your Honor, if you were done with what you needed to do, but.
I'm done with what I needed to do, so.
Then if we could adjust bond, Your Honor, Ms. Carr, either her or someone close to her posted the bond in this matter. I'm wondering if we could, I guess because she's been sentenced, I think bond conditions would extinguish, but if they have not, I would just ask for the bond to be changed to a PR so that money can be refunded to either her or whoever posted it.
Okay.
I don't object to that.
All right, so I will mark okay to return bond on the paperwork, and that should be taken care of. All right. All right. All right, so Ms. Carr, I want to commend you for the hard work because what you're doing is not easy, and it probably benefited you by helping you get it deferred on this file as well. So I wish you the best of luck. And do I need to put a date for end of this or no?
Judge, let me check the expiration again. And then I'll let Becky know.
All right, so we may have to put an end date for a court hearing or not, Ms. Carr, but you'll get that notice through our office, okay?
Okay, sounds good. Thank you.
All right, thank you. Good luck.
Have a good Thanksgiving.
You too. Okay, so I have Mr. Upshaw, your client, and Mr. Caleb. That was Mr. Glazier. All right, so we're back on the record in the matter of the people of the state of Michigan versus Caleb Matthew Young. Mr. Glazier, you would ask for an opportunity to speak with Mr. Young. Have you had an opportunity to do so?
I have, Your Honor, and at this time, my client's going to enter a plea of guilty to count 1, identity theft, and as well as count 5 and count 6, which are misdemeanors.
All right.
And there was,
Mr. Upshaw,
Your Honor, there would also be a Killebrew plea that there would be no upfront jail on those charges, and we'd like to address bond after the plea is entered.
okay, Mr. Upshaw, will you be taking a plea with your client today or?
I do believe
getting
so,
another
Your Honor.
date?
No, I do believe
You will
we'll be
be?
entering a plea today, yes.
Okay, all right, so just hang on 1 second. All right, so Killebrew to no upfront jail at the time of sentencing. All right, so Mr. Young, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
All right, so Mr. Young, before we get started, I wanted to ask one question of you. I am handling this file for Judge Olsaber because he is gone this week. And so I will be taking your plea, but do you have any objection to, you have a right to be sentenced by the judge that took your plea, but you can waive that right and be sentenced by the judge that is assigned your file. So do you have any objection to waiving being sentenced by me and being sentenced by Judge Olsaver, or? Do you
No, it don't matter to me, Your Honor, who sentences me.
Okay, all right.
Sorry, the internet connection here is bouncing in and out. It's saying that the network bandwidth is low, so you're bouncing in and out on me. I'm sorry.
I'm so sorry. Hold on, let me turn off the video from the courtroom. And then I'm
Okay.
going to, all right, so Mr. Upshaw, if you can turn off your video, and Miss, I'm gonna pop you in the waiting room and you'll be up next, okay? All right, so that should maybe possibly help. Okay.
It says your internet connection is unstable. I don't know if it's you or the jail. It just keeps saying that, and it's like bouncing in and out on your voice.
I know, and just let me know if it becomes a problem, all right?
Yes, ma'am.
Okay. All right, so, all right. So I swore you in. Can you state your full name for the record?
My name is Caleb Matthew Young, Your Honor.
All right. So Mr. Young, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to 3 counts? Count 1, identity theft that carries a maximum penalty of up to 5 years in prison and or a $25,000 fine, as well as count 5, intentional dissemination of sexually explicit visual material, which is a 93-day misdemeanor and has up to a $500 fine. And count 6, computers using to commit a crime, maximum imprisonment of 1 year or less. So it carries a maximum penalty of up to 1 year in jail and or a $5,000 fine, as well as reimbursement of government expenses. So is it your intention to plead guilty to all 3 of those counts?
It is, Your Honor, yes.
Okay, are you satisfied with Mr. Glazier as your attorney and the advice that he has given you?
Absolutely, I am. Yes, ma'am.
All right, other than a Killebrew agreement to no upfront jail, neither the prosecutor, the defendant, nor anyone on your behalf has discussed a possible sentence with court in terms of length of probation or fines and costs. Is that correct, Mr. Glazier?
Yes, Your Honor.
Mr. Sneed?
Your Honor, I would just add, in addition, the defendants to admit all for sentencing purposes to the probation department. The people have no objection to his entry into 3 Rivers as well. So.
Okay, that's a bigger note. Okay, hold on.
And finally, I did want to inquire if Mr. Glazer is having his client plead guilty or no contest.
He'll plead guilty.
Okay, thank you. Then we're prepared to proceed, Judge.
Okay, hold on, I gotta change my note for Judge Olsaver. And what was it about 3 Rivers?
People have no objection to his entry into 3 Rivers Rehabilitation Facility.
Okay, I think I got it now. Okay. All right, so Mr. Young, other than that, I'm gonna ask you again. There's been no other possible sentence discussed with the court as far as you're aware, Mr. Young.
Not that I know of, no, Your Honor.
Okay, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. Do you understand that, Mr. Young?
Yes, Your Honor, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor, I do.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any, and there's no, okay. Do you have any questions about the rights that I've given to you?
No, Your Honor, I do not.
All right, so Mr. Young, how do you wish to plead to the charge that on or above October 1 of 2021 in the city of Adrian in the county of Lenawee, that you did commit the offense of identity theft?
Guilty, Your Honor.
All right, and on October 1st of 2021 in the city of Adrian in the county of Lenawee, how do you plead to the charge that you committed the offense of intentional dissemination of sexually explicit visual material? Guilty or not guilty?
Guilty, Your Honor.
And on that same date and time in the city of Adrian, how do you plead to the charge that you did commit the offense of computers using to commit a crime? Guilty or not guilty?
Guilty, Your Honor.
All right, has anyone made any threats or promises to you to induce you to plead guilty to these charges other than what was placed on the record?
No, Your Honor.
All right, do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yeah, yes, Your Honor, I do.
All right, is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier
No, Your Honor.
and Mr. Sneed.
No, Your Honor. Thank
All
you.
right, so Mr. Young, has your attorney promised you any particular sentence or estimated what your sentence will be other than what was placed on the record?
No, Your Honor.
All right, is it your own choice to plead guilty?
Yes, yes, Your Honor.
Okay. All right, so Mr. Young, on October 1 of 2021, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor, I was.
All right, and I'm going to use initials, so I'm not going to state the person's full name, but their initials would be JS.
Yes.
So, okay, so did you, with intent to defraud or violate the law, use the personal identifying information of JS to obtain unemployment benefits?
Yes, Your Honor.
Okay, and you didn't have permission to do that,
No, I didn't, Your Honor.
and you had no legal right to do that, correct?
No, Your Honor.
All right, Mr. Steen.
People are satisfied, Judge. Thank you.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Glazier
Yes, it has, Your Honor.
and Mr. Steen.
Yes, Your Honor.
Oh, I guess, all right, let's move on to count 5. So on that same day, October 1 of 2021 in the city of Adrian, in the county of Lenawee, same individual, same initials. Did you person was not listening. All right, so did you send out or text or Insta or TikTok or send out somehow some sexually explicit visual material of JS, like photos or a video, to anyone other than you and JS?
Yes, Your Honor. To OnlyFans. OnlyFans. Yeah.
Okay, and when you did that, was it to threaten her, coerce, or intimidate her?
Yes, Your Honor. Yes, I did.
Okay, Mr.
Yeah.
Steen?
I just wanted, for purpose of the statute, that she was not under the age of 18.
She's over 18, right?
Yeah, she's 25 now, Your Honor. Last year she was
Okay,
20.
that's what we're saying. She's over 18. Okay. Mr. Sneed, anything else on that one?
And just establish he knew that she did not consent to the dissemination of that material.
She didn't agree for you to put that on OnlyFans, right?
No, Your Honor, no, she didn't.
Okay,
Thank you, Judge.
all right. And then on count 6, Mr. Young, on that same day, the city of Adrian, you used a computer. Is this to upload the material, Mr. Sneed? Is count 6 the uploading of the material?
It is, Judge, yes.
All right, so when you uploaded up to OnlyFans, did you use a computer to do that?
Yes, Your Honor.
All right, and, all right, Mr. Sneed, any other questions about that?
No, people are satisfied.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Glazier,
Yes, it has, Your Honor.
Mr. Sneed?
Yes, thank you, Your Honor.
All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. There has been an agreement placed on the record, and I'm presuming that Judge Oldsaver will honor that. But other than that, the court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department, and we will set sentencing for January 12th in front of Judge Oldsaver at 8:15 in the morning. Now, Mr. Young, before I ask you about Zoom sentencing, and we're going to address your bond, evidently Mr. Glazier wants to bring that up. At the end of when we're done with your hearing, I'm going to put you in a breakout room with Miss Holly from the Michigan Department of Corrections, and she's going to give you instructions on how to proceed, because you're going to need to contact them, meet with them so that they can prepare a pre-sentence report. When you meet with them, be truthful about your background and the events that occurred. They'll prepare that report. Mr. Glazier will review that with you in advance of sentencing. And all right, so Mr. Glazier, you had something you wanted to address regarding that.
Yes, Your Honor. My client is in jail. He was in jail on a different charge, but I guess he has served the time. He's actually been in jail 9 months. And so we had asked that he be granted a PR bond pending sentence here. I've discussed with him the importance of showing back up would be 100 times worse, and he's well aware of that. In fact, he's still on probation with Judge Oldsaver, and he'll have to follow the terms of that probation. Whether he's going to get into the program or not, I guess we're not certain at this time, but that was the recommendation before, and I don't know if that'll be the recommendation on this sentencing or not. I guess we'll find out.
Will there be a violation of probation?
No, Your Honor, I was put on probation for the crime I'm in here on now, so all this happened last year before.
Hold on, Mr. Young, you're breaking up for us too. So the answer is no, Mr. Young?
It will not be a violation of probation, Your Honor. He was not on probation when this offense occurred.
Okay, Mr. Sneed, any position?
Your Honor, the people wouldn't object to a conditional PR bond if he is to enter Three Rivers. That's what was expressed at the probable cause conference. That was the understanding of the people. That was Mr. Young's intention. So
it's actually called Twin Counties.
Twin Counties now. She's
It's always been
right.
Twin
So,
Counties.
so that means he can only be released to Twin Counties?
that would be the people's position, Judge.
Mr. Glazier?
I don't know if they're going to recommend Twin Counties again or not, but I understand what Mr. Sneed is saying.
Okay, so I'm willing to put the bond that the defendant may be released to Twin Counties when a bed becomes available prior to sentencing. That's fine with me. Mr. Glazier, do you want to add anything to that?
Yeah, we don't want it to be a PR if he doesn't get out, obviously.
It wouldn't be a PR. You're on probation with who, Mr. Young?
Chris Jones.
All right, so I'm gonna put in here that you can be released to Twin Counties once a bed's available prior to sentencing, and Mr. Jones typically just will come over and let us know when we change the bond. All right.
Yes, Your Honor.
Okay. Thanks.
I don't think they'll take them prior to sentencing, but
They won't take me prior to sentencing. That's why I've been sitting in here for 9 months. Hey, I was eligible to go in September, but these cases popped up.
Okay, so I'm gonna put that in there, but as I said, you may be here until sentencing. So, all right. Now, Mr. Young, my next question for you, I'm also, you do have a right to appear in person for sentencing, or you can appear via Zoom. So at sentencing, do you want to appear via Zoom or do you want to be in person?
Whatever's easiest for the court.
Well, if either is fine for me, I'm asking what your preference is. Because I mean, like, so
In person, Your Honor.
Say it again.
In person.
Okay. The reason I ask is Zoom, you're like you are today, and in person, you know, they get you over here and you sit in a holding cell for a couple hours. So
Right.
it's just making it your option, but you would like in person, correct?
Yes, Your Honor.
All right, so Mr. Glazier, we will put that on the docket. And all right, so we'll see you back in front of Judge Olsaver on January 12th at 8:15 in the morning in person. Mr. Jones will get a hold of you and he'll do an update on your pre-sentence report. And you're on probation for Mr. Jones, but Mr. Sneed, I don't have a habitual offender notice on the felony information. So, all right, thank you, Mr. Young.
Well, can I have a breakout with Mr. Glazier, ma'am?
I don't have time for it this morning because you're the only jail cell I have and I have to finish my docket, but Mr. Glazier can reach out to you at the jail.
Oh, please do, Mr. Glazier.
All right, I'll try to get a hold of you.
Yeah, please do.
Thank you.
Mr. Upshaw, I'm gonna bring your client back in and let's see. So back in, you got Mr. Judge Olsaver's docket done. All right, Mr. Upshaw, let me grab your file, and it's Ms. Velasquez. And I think that's who, no, I have a young lady on an iPhone. Are you Ms. Velasquez?
Yes.
Excellent. All right, so this is in the matter of the people of the state of Michigan versus, is it Valencia?
Yes.
Velasquez, file number 22-21086FH. I have Randall P. Upshaw, P43574, appearing on behalf of Ms. Velasquez, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. Mr. Upshaw, how would you like to proceed?
Your Honor, thank you. We had a prior meeting with the prosecutor. It wasn't Mr. Sneed there, but I'm hoping Mr. Sneed honors and has no objection to a plea under HIDA.
I do not. I do have notes from Ms. Wise regarding the case.
Okay, so okay, so there'll be a plea under HIDA. So so it'd be pleading Mr. Upshaw to count 1 under the Homes Youthful Training Act.
Yes, Your Honor.
All right, excellent. All right.
And Your Honor, if we may, sometimes I have a brief problem. Is it possible here that we can take this plea and just kind of hold it under abeyance? Because what happens when you plead under HIDA before her sentencing is entered onto her record and it affects her employment. So what we do sometimes is we take the plea and just kind of hold it under abeyance or under advisement, then she gets sentenced, but it won't go on her record where it cause her to be terminated because she's in the nursing field.
So
Or just don't send it to who, is some way you don't send it to where it appear on Otis and things of that nature.
So that's like way above my pay grade because I have no idea what happens to these files. So Ms. McGreen, are you able to get any information on that for me?
I apologize, Judge. I just got back to my desk. What is the question?
So Mr. Upshaw was inquiring that in some counties, if I take a plea under HIDA, does it get entered into lien? I don't think it does under HIDA. Is that correct?
Judge, I just talked to the clerk's office and they said it does.
Okay.
And what I-
So,
It shows up, but it says under HIDA.
is that, but it's suppressed. Would it be available to the public on lien?
Only if they can run a lien. It'll say.
Most employers
suppressed.
don't have authorization to run a lien.
And if some system, if some courts, they take it and they place it under a certain part where it says HIDA, then it won't go. And we're satisfied with that. Some judges still send it straight on and enters into the liens, onto her record. And we have to file a motion to have it removed. So I'm just trying to avoid that. As long as they place it where it's not accessible to the public, we appreciate it.